Good morning, everyone. Good morning, Jay-Z, Holly's mom, Nikki. Let's talk about the truth. We need the truth, the whole truth, the whole truth. And Sarah Boone is notorious for not telling the whole truth. Her letters evidence that, her words, her behavior, all of it. And any assessment, whether it's by a professional, by a juror, by a member of the public, is only as good as the information that you have. The smartest person in the world, not having all of the facts, is not going to come to a correct conclusion. You can't. So I'm frustrated and I'm cranky today. So if my tone of voice sounds off sometimes, please know it is not directed at you. I want the truth. I always want the truth when there's a trial. Somebody's fighting for their life and somebody lost their life. But there are some things that we do know, and one is that the defendant is a notorious liar. We know that the defendant's main interest is herself. And I want to talk about conflating issues. Did the victim get physical with her? The answer is yes, he did. We've always known that. Yes, he did. And is that okay? No, it's not okay. I don't care who you are. I don't care how unlikable you are. It doesn't matter. Nobody should be laying hands on anybody. But what she was failing to disclose, and we all know, is that she went after him. And she did a lot of things. Think about that power and control wheel. Think about Dr. Brennan and his description of what BSS is about. She fits all of it, not as the victim, but as the perpetrator, as the primary aggressor. And she conveniently leaves out anything that makes her look bad. She denies anything that makes her look bad. And even in explaining what he allegedly did, his overt act, and by the way, we all saw the videos and the pictures. We know that suitcase was zipped shut. We know that. And I lost my train of thought. He didn't do. Oh, I know. When she was explaining the alleged threat and what the overt act was, she said, I guess. I guess. That was her testimony. I guess and probably. And the two times that she brought up the threat, first time it was one threat, the second time it was a completely different thing that he allegedly said. She can't even keep her story straight within the 10 minutes that she's talking. So I'm frustrated. Mr. Torres is not getting his truth known. And everybody's buying the hide and seek malarkey. So I'm ticked off. But let's not conflate the fact that, yes, he got physical with her with justification for what she did. Even if you wanted to believe everything she said, if you wanted to close your eyes and ignore the evidence in front of you and believe all of it, does it justify taking actions and omissions in a vengeful way that ultimately result in his demise? Is that okay? If the situation were reversed and it was her inside the suitcase And it was Mr. Torres taunting her as she begged for her life. Would anyone think that was justified? You look at the comments. Jay-Z, she felt safe enough to go to sleep. Yes. Yes. Somebody saying anything less than manslaughter will be another travesty of justice. Uh, uh, Someone saying justice would have been second degree, but the prosecutor dropped the ball on cross. A lot of people are saying that. I don't know. I think it's really hard when you're in it. You know all the facts. It's really hard to put yourself in the shoes of the jury. Hard to put yourself in the shoes of someone who doesn't know any of the facts. The prosecution and the defense have been immersed in this for a long time. And what seems obvious to us may not be obvious to someone who hasn't followed closely. So is that dropping the ball? Or, I mean, maybe, or maybe they have a different strategy. Maybe they're waiting for rebuttal. Maybe, I mean, if you object to every one of her lies, we'd be here forever. And the jury would be irritated at all the objections. So, I don't know. I feel I'm not comfortable passing judgment on them. I'm not in their shoes. William Carl says, I left a sink full of dishes for the afternoon break. Yeah, we need to do something, right, for self-care. This is very frustrating. Hi, Kim. Anne says she just had to call the police to get him out of her apartment. Yeah. And she'd done so before. So it's not like she couldn't. It's not like she didn't know. Oh, okay. Somebody's asking about the motion. So I'm going to show you a document. And let's go over that. Wait, let me just check. Okay, we're going to be starting soon. So if they start, I'm going to jump out of this document. So this comes now the state of Florida alleging the defendant is indigent. She has had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving costs money from JAC because of her indigency. Apparently, only investigator Billy Lane is being paid with JAC money. The defendant has secured the services of 4 attorneys and a jury trial consultant, and perhaps more people that the state is unaware of at this time. The defense team is expending a tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for a several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida and then traveled back after it had passed, incurring additional costs. The state is concerned about a potential conflict of interest between the defendant and her team, and they cite rules. The only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial arrangements between the defendant and her team. If there is an actual conflict, the defendant can waive this right with a clear, unequivocal, goodness, I can't speak, unequivocal and unambiguous language. For the waiver to be valid, the record must show that the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and the defendant knew of the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination, so it's not going to be televised, of the financial arrangement to assure that there is no actual conflict of interest. And if there is, the defendant validly waives any actual conflict of interest. I'm going to come back. I just want to check the stream, see. Okay. I'm going to come back to chat. So I'm going to look at your comments. So basically, Mr. J is doing the right thing. He's not only protecting the case and the state, right? This actually protects Sarah potentially from being exploited. So all the way from the beginning, Mr. Owens was kind of non-committal about the financial arrangements. He tells the court he's pro bono. Then he tells Court TV, oh yeah, don't worry, she's going to pay me back. She owes me, right? He's spending all this money. I mean, anybody in law knows, if the money's funny, you start following it, right? Follow the money. So something's rotten in Denmark, it seems like. So Mr. J can't come out and say that, and frankly, neither can I. It's just odd, right? So he wants to know, and he wants to make sure the court knows that there is no issue of exploitation, that there isn't something untoward happening between the defense team and the defendant. And if there's something, unusual that, excuse me, I got something in my eye, that could be seen as exploitative, that the defendant herself is well aware of the nature and quality and consequences of what is happening, make sure she's aware. We don't want for her to later claim there was a conflict and say, I want a retrial. And regardless of how much we don't like her, we don't want defendants, people in vulnerable positions, and she is because she's incarcerated. We don't want people in vulnerable positions to be messed with, played with unfairly. Let's put it that way. So Mr. J wants to make sure that's not happening. Mel's talking about the Son of Sam law. I'm hearing that the Son of Sam law isn't really enforced that much in Florida. I don't know if that's true. Hi, London, England. Holly's mom says can't be pro bono and a paid attorney at the same time. That's right. Working on a contingency, working on a deferment plan, that's not pro bono. We've talked about this before. So what the heck? What's the arrangement? So that's what this is about. I cannot speculate on what that arrangement is or isn't, or if it's proper or not proper. I don't have facts, right? I don't know what went on behind closed doors. So I can't make a statement or come to a conclusion. I'm just letting you know this is the motion. People are saying that, and even there was a news station who reported, he agreed to like a book deal or rights. She's signing away rights or something like that. That's not what the court document says. So I'm not going to say that that's true or even probably true. The truth is we don't know what the truth is. So the judge and Mr. J and the defense team have to be on it, and they're going to be. And so there will be a discussion about this. And I trust that the judge is going to do the right thing. So that's the news from there. So I'm just going to check the chat. Good morning, Connecticut. Hiya, Buttercup. Nala stole the spoon. Says it's my understanding the judge has to make the order to put the son of Sam law in place. Good. But that might not be what this is about. Don't know. But the defense team is spending quite a bit of money. Good morning, Stephanie. Hello, UK. Castro is saying, is somebody thinking Sarah could have a book or movie deal that he could benefit from, or he could have the book deal or movie deal, right? But that is all speculation. That is not fact that we know about. We just do not know. The son of Sam Law, somebody's asking what it is. And Florida people, correct me if I'm wrong, I believe the son of Sam law says that an offender can't benefit financially from their offense. So you can't sell t shirts and books and get the money because you were a criminal. Good morning, Christine. Oh, you guys are good afternoon in the UK. Jay-Z is asking, would the son of Sam law extend to her lawyers? I don't think so, but I don't know enough about it. So I can't answer clearly. Sorry. Hiya, Lala. Layla? Layla, sorry. Good morning, Squid. Good morning, Ingrid. Good morning, Tracy. KPM says Mr. J cited Florida law. Yeah. You think that Florida law he cited is related to book deals? I don't know. I'd have to look it up. Stephanie is asking, would they file this if they thought they were winning? I think they would file it either way. I think whether they're winning or losing is irrelevant. If it's appropriate and proper, it is. And if it's not, it's not, regardless of the disposition in the end of the trial. Somebody's asking, can the state call Sarah on rebuttal? I have never heard of that happening. And so my answer would be no, but there's a caveat here. I don't know all the case law in Florida and all of that. So it's possible there's a loophole. So I don't know, and I don't know that they would, even if they could. Sorry, I can't give you a better answer there. Oh, or do we have a stream? Here we go. Thank you for. I'm actually going to change screens again just want to check my volume. And to let you know, I'm going to try to stream from Trial TV Live. And big shout out and thank you to them. I will put a link in the description to their channel. They stream other trials too, if you're ever interested, without commentary, because some people don't like the commentary. DLV is asking, why hasn't the state brought up the fact that George was never accused of domestic violence prior to Sarah? There are a lot of reasons. One is they haven't had the chance yet. the defense has to open the door specifically to that. But, you know, if I was the defense, I would argue, well, just because he didn't do it before, it doesn't mean he didn't do it now. If I wanted to play devil's advocate there. Oh, Buttercup. You seeing commercials? Yeah. And you know what? My videos on Boone keep getting demonetized. Nice, eh? Because I guess you're not allowed to talk about DV to, I don't know, too blatantly. I enjoy talking to you guys. Castro says, I will try to be nicer to Sarah. No, you don't. Your commentary is not the problem. It's me. Because I keep talking about DV. I talk about, I say the word for unaliving. Because it's really hard to censor yourself so much while you're trying to talk about a serious subject and give it the respect it deserves. Plus, I get ticked off, and there was a couple of people yesterday really mad at me because I don't feel sorry for her, and somebody said I was doing a disservice to women. And you know, I don't care whether the victim is male or female. You can't lie about that stuff. That's the disservice. Don't lie about that. That does the disservice to everybody, to every victim. It's Dr. Tracy is saying, yeah, we can't talk about DV. Why talk about something that needs to be discussed? It upsets so many people. People have polarized opinions still. I remember going, like, marching on City Hall and stuff in early 1980s. I'm showing my age. And
case number 2020-2603, Sam Flora versus Sarah Boone.
I just want to finish my thought. And I think nowadays I'm hearing the comments and I see the way people are about these subjects, and I think, are you kidding me? We're still arguing about this. Are you kidding me?
Names for the record, beginning with the state.
Dave Cacciatore on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Evan back on behalf of the state.
Ms. Boone, raise your right hand to be sworn. Please be swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a market report for any of these?
Correct.
Okay.
Right now, their ID as AD, as in boy, and EC as in.
Defense Identification AB, Judge, which is the order dated June 16th of 2019. It's a no contact order. And then identification is AC.
Do you want to introduce the no contact order? They're going to make him sound like a crazy stalker guy when it was her who went after him.
2019. And then I'd like to introduce them into evidence. And then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we bring the jury in?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions, the court has reviewed both of the no contact orders. And that way we don't have to do a in and out, and I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right.
Ooh, that's good. So they're just going to introduce the exhibits, the no contact orders, as proof for the jury and maybe rest their case? Oh, good. We don't have to hear any more of this nonsense?
Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
That one's the 6th.
I don't believe so. Give me a moment and I can check.
No, they didn't rest yesterday, Buttercup.
That is an alternate. It's alternate seat 4.
Thank you.
CJ is saying he didn't understand that even with her permission, she couldn't invite him back, which she knew because she called the cops on him. This is common. I can't tell you how many times an accused has been brought in for a breach on a no contact order and says to the court, "But Your Honor, she called me. She invited me back." And the response to that is, buddy, the restraining order or the protective order, whatever, your jurisdiction, whatever it is, the no contact order applies to you, not the victim. You can't have any, here it's direct or indirect contact. You can't do it. The other person is not subject to that no contact order. So Sarah could call him and drop by and send him messages all she wants. She's not under a no contact order. He is. So if he breaches that, he is the one who gets charged. So for any of you out there, if there's ever a no contact order on you, doesn't matter what the other person does. You don't breach that. You don't. And a lot of people don't understand that. At one point, the officer did explain that to him. So, yeah, that's a good point.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal pursuant to defense resting. I'm going to do that now while the jury is still out.
Okay.
I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders, pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
People are asking what's happening. So Mr. Beck got up because the defense is resting. They want to get on the record. We're moving for acquittal again. It's pro forma, really. We don't have any additional arguments aside from what we said the other day in our arguments. Mr. J said, yeah, our response is the same. The judge says, yep, my decision is the same. So, it was just a thing that they have to do. They had to do that for the record for later. Now, the judge is making sure that Sarah is satisfied with everything, that she's not being prevented from getting evidence in and all of that. Everybody's CYA right now.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now. Owens' email.
Whoops.
Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay. All right. Very good.
Lala, if you can't unzip, you must convict. You're funny. And Dr. Tracy mentioned, the nuances of DV. Yeah, it's not black
All right.
and white.
Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right. Let's stand and bring in our panel, please.
Kat's asking if I think the state will put in the body cam where they're both arrested in rebuttal. I'm guessing so. But who knows? It was in discovery, though. No, not closing arguments yet. The state still has to do their rebuttal case. That's what I'm banking on. We need the jury to see the truth as much as possible. I'm disappointed that through the trial we didn't get the truth. George's story really wasn't told. So it's frustrating.
Jury's entering.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I did.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning. and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to...
You may proceed.
The first is defense exhibit 19. We'll just review it and pass it down. Next document is defense exhibit 20.
Sorry, I want to address some things I'm seeing in the chat. People are talking today, and actually over the course of this trial, how upset you were. I really appreciate how people are with each other, how you guys are with each other in the chat. A lot of people are watching the trial, and in real life, they don't have anyone to vent to. You can vent to each other. And please, self-care is so important. If you're angry, go punch your pillow, go lift something heavy safely, go do whatever it is that helps you to cope, that helps you to distress. Go do that. That's important. Understanding these issues that are raised here, witnessing this stuff, I think does matter. I think it is important. But your health and your mental health is more important. It is normal to be upset by this. It's normal to be angry, to be frustrated, to be distraught, to be triggered, all of it. That you are normal. You are a normal feeling human being. So know that, but please do whatever you need to do to take care of yourself, and share with each other in the chat and in the comments what you do to help yourself, to take care of yourself, because it might give somebody else an idea they hadn't thought of. Everybody's different in how they do self-care. What works for me may not work for you. So I just wanted to mention that. You matter, your mental health matters, your real life matters. Sarcasm about snacks is still allowed. Humor is a way of coping. That's one of my big ones. I have to be careful because sometimes it's dark.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you. State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
State calls Dr. Tanya Warner.
Yeah, let's go.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya, T-O-N-I-A, Warner, W-E-R-N-E-R.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University.
I just want to point out that her initial education was chemistry. And the reason I like it is, it seems to have nothing to do with anything that we're dealing with here. But the reason I like it is because she is trained in her foundations is in scientific thought. So she's going to have a way of thinking that, for me, will resonate with me.
I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
So she's worked for both the prosecution and the defense.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
Yeah, this is funny because the expert is here talking about her field of expertise, and Mr. J is asking a question that he knows it's going to irk Owens, and you can hear in the background Owens is irked because there's an issue in law about subjective versus objective and where those elements fit in. But this witness hasn't been around listening to all this, so she doesn't know that. So it's going to sound weird to her.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience.
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having this syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida?
Yes, it was.
So this doctor saw Boone October 2nd, long after Boone had ample opportunity to see all the evidence against her and to make up her story and get that sorted out. So we're going to see whether or not this doctor clued in to the lies. We'll see.
And subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room, again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information.
I just want to point out something again here. The subject, Sarah, was made aware that it's not confidential. So this, covers off a couple of things. One is that this professional is doing her job. It would be unethical to not let Sarah know that. But also, Sarah knows, and this is in front of an audience too, right? Sarah knows this is for an audience. And Sarah knows that she needs to say and not say certain things because it's going to benefit her. So she has motive to fabricate. Now, having motive to fabricate doesn't always mean that the person does fabricate, but that is something to keep in mind, is Sarah knows it is for the benefit of an audience.
Who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to...
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4:00 in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there.
Notice what's missing from the story. So, well, first of all, she doesn't even know if they got up in the morning or later. So did they get up at noon and go straight to Publix? Anyway, she is omitting going to Publix and buying the bottle of wine. And she is, again, Sarah, omitting the second bottle of wine. She's describing it like they had a half a bottle of wine left over and they went out back and were playing darts and having that half a bottle of wine. Sarah is notorious for not telling the whole truth.
A lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek.
Just want to point out that the expert here has been asked to relay what Sarah told her. That does not mean, A, that what Sarah said was true, nor does it mean that the expert believes Sarah. She's just saying, this is what she told me.
And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him, and as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And, sorry. And
that's so frustrating when you're talking and, that's so frustrating. I wish they would just let her turn around and like cough for a minute.
So she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up. And they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her. And she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
This is a key point. She became angry. We all saw the video. We know she was angry and vengeful, right? She became angry, and this is revenge. Anger is not, I'm fearing for my life. The overt act was hers. The overt act was her, not him. The one fighting for their life was him, not her. But everybody wants to believe her BS.
To refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck two fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
She beat the suitcase because she was angry. His two fingers came out. I don't believe that. But even in Sarah's story to the doctor, is that his two fingers came out, not a hand, as the lawyer indicated. And she smacked his hand. She's not saying at this point, I smacked his hand because I was scared. I smacked his hand because he threatened that he was coming out to get me. None of that. No uttering the threat. None of that. So it's yet another story. Sarah learned through court proceedings that she needed to improve upon this story. And voila, out comes a threat that is really vague and changes in 5 minutes of testimony. Very interesting. I hope the jury is picking up on all this.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because, again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, if we could approach the bench.
Yes.
You know that with this answer that she's given, that Owens is going to point out, well, Dr. Julie Harper saw Sarah 9 times. This doctor only saw her once. But I think it's fair for this doctor to say, you know, if I had more information, my opinion would be subject to change. I think that's great because it shows me that she has an open mind. She's not invested in one thing or another. She doesn't care. She just wants to get as accurate an assessment as possible. And at the beginning of this stream, I talked about getting the whole truth. And that was before I knew obviously I didn't know she was going to say this, but it matters. Jay-Z says, yeah, Sarah had to alter her story after knowing what the evidence was. I'm trying to fast forward past this break without going too far. Joyce says, yeah, she's an independent professional. Yeah, she doesn't care. It's not her job for a case to win or lose. In fact, it's not any expert's job, really. Crystal Dawn saying, yeah, if the roles were reversed, it was Sarah in this suitcase, this case would be totally different. Yes. And that it does speak to a bias against male victims. And, when I say that, that is not at all to discount the fact that the majority of DV victims are female. And let's not forget all the children who suffer as a result of DV. But that doesn't mean that men are less important or less valid. Jay-Z's
Or I have to discuss with council outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct.
Someone in the chat said it's not a competition. That's exactly right. Both things can be true and valid. And, male or female, I don't like this, making the division and then getting, arguing. Who's better? Who's more deserving? Blah, blah. We're talking about human beings. Regardless of your gender, you are a human being. And that matters. And no human being, and I would argue no sentient being for that matter, deserves to endure cruelty. You should not be subjected to violence, no matter who you are. And I don't care if you're a jerk. I don't care if you're a high maintenance princess. I don't care if you're the most annoying person on earth. I don't care if you're employed or unemployed. I don't care what color your skin is, what language you speak, what religion you are. You're a human being and should not be subject to abuse. That's it. It doesn't matter. It's not okay. Just going to try and fast forward this stuff. Yes, men get stigmatized when they discuss their
Be seated.
feelings.
Thank you. Mr. Rowan, see if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. We're set for trial October 7 for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. And I respond on page 40, line 23. I'm not suggesting that, Mr. J.
So I'm just making sure, is everybody understanding what is happening? Okay. So in case someone isn't, they're talking about a discussion that they had this hasn't been aired before to the public. This was during the deposition of this witness. And what the doctor was saying is, well, I really need to think about this before I say this is my final opinion and these are my diagnoses. I need to go through the notes. I need to think about it before I'm locked into an opinion, because if there's other information, my opinion might change. So from the point of view of someone doing an assessment, that is the right way to go about it. Look, I want to make sure I haven't missed anything. I want to make sure I'm doing this right. If she was on one side or the other, she would just say, oh yeah, and just go with one side and cherry pick. But she's not. And she's saying, well, if there's other information, I might change my mind, which is exactly the right way to think. I've started assessments and then received other information that changed the color of everything, right? But these guys, both the prosecution and the defense, they need to get to court. There isn't time to fart around. So Owens doesn't want he wants to argue now. So this is what he's reading. Okay, that's what was going on. I'm just going to shut up. I think you got it.
I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder.
Sorry, Aaron, the jury is not in the room right now. They're not hearing all this.
In some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay.
The whole
Starts
truth.
On line 15.
The whole truth, Owens.
So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the doctor, Werner, was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to discuss.
So note, they're talking about generalized anxiety disorder versus an adjustment disorder. An adjustment disorder would be temporary and would eventually resolve itself on its own. A generalized anxiety disorder would not necessarily. So that's what they're arguing about here. They're not actually arguing about PTSD or battered spouse. I find this interesting. I'm just kind of hanging on to those facts, waiting to see how Owens weaves this into what his problem is. We heard from Dr. Brennan, and Dr. Harper might have brought it up too. But when a clinician is doing, or not just a clinician, a forensic examiner is doing an assessment, they have to make sure that they're not misdiagnosing, that, if these are present, consider this diagnosis before you consider that. If this thing is present, consider its impact on this. So that is what the professional was doing at the time of this deposition. She wanted to make sure. And so I'm still not quite sure how this fits into what Owen's problem is right now.
Post her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that. And then, paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples.
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion
The non-objection that led to objection. This judge is great.
specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria.
No, I don't believe it. No, I haven't diagnosed that. No, she hasn't given me the criteria. But I'm willing to go back and look through my notes to make sure I didn't miss anything.
Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer. I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
But the doctor's testimony on the stand is not different. It hasn't changed. I mean, unless she said that and I completely missed it. And it's frustrating to have to sit there on the stand and watch lawyers play games with your words and you're not allowed to say anything.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But
you didn't refuse to take the deposition. And you didn't raise this objection before. So now, after jeopardy is attached, at the end, near the end of the trial, now you're going to retroactively object? It's not like Owens has some new information or surprise information here. Wow.
under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
Yeah, I was there.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change.
I have no legal grounds, but I object anyway. Because I don't like the answer. Don't let the mean prosecutor do this to me.
Opinion, and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
Okay. That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay. As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given.
And if Owens doesn't like the answer or doesn't agree with the prosecutor's interpretation or how it's going to sound to the jury, all of that, then Owens will have opportunity to address that issue with the jury within the trial here. So he could address it.
So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Yes. Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
I think this is a stretch to say it's a discovery violation, but we'll see what the arguments are. Owens is saying, yeah, she's given a legal opinion, but she is a forensic psychologist. If she was a psychologist without the forensic attached, Owens would be right. But I'm not so sure because she has the forensics, right? So this very interesting to me anyway. I hope nobody's bored with this back and forth.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer, 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it.
Yeah. I don't have a crystal ball. I've told you my opinion on everything I've answered. Nothing has changed. I'm still not entirely sure what Owen's grounds are here for all of this.
Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today.
I'm trying to figure out what the change in opinion was. What did I miss there? I didn't see any change in opinion. Is he going for a mistrial? I have been worried from the get-go that they would purposely pull something to create a mistrial. He's going on about discovery violation. Oh boy.
And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I'd have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Sorry, I'm letting it run because I don't want to miss anything here. And we're a little bit behind, so if anyone knows what happens, please do not put it in the chat.
Court's going to step off for a moment while Madam Court Reporter is able to provide that readback.
Okay, so I can fast forward a little bit. The judge is like, yeah, get your crap together, people. Now we got to go through all this. Now the court reporter has to do this. The jury's waiting. The expert witness is sitting there on the stand, unable to actually say anything. Probably knows how ridiculous it all is. Blink Bunny points out Sarah's changed her story plenty. Yep. I'm only slightly worried. I'm not terribly worried. And the reason I'm only slightly worried is that you never know. So somebody in the chat saying, hey, I'm fuming. Why? Because of Owens? Criminal Minds. Judge K probably has a punching bag in his chambers for moments like this. I don't know. Probably he doesn't strike me as that. Deep breathing was probably more his thing. There was a justice of the peace who used to take a recess and would call me, like order me, like come back to the where everybody thought I was going to chambers. I wasn't. I was going out back for a smoke with them. We didn't discuss any of the proceedings happening ever, but yeah, sometimes you need to just let off some steam. The first time that happened, when I was called to chambers, I was crapping my pants, man. I'm thinking, oh my gosh, what did I do? And everybody was saying, ooh, Lori, you're in trouble. I was so scared. And when I get back there, he says, yeah, I heard you smoke. Come on back with me. I was like, okay. Good morning, Jackie. We're just waiting for the judge to come back. The court reporter is looking for something. Joy is asking, did they talk about the movie or book? Whether that issue had a movie or a book tied to it is purely speculation. The document was about, the motion from the state was about, actually it wasn't a motion, they wanted a discussion in camera. It was about what are the financial arrangements and whether or not within those financial arrangements, is there something that creates a conflict between the defendant and the defense team in whole or in part? Matcha, they are arguing about, Owens is complaining about one of the answers she gave. and was objecting, and it wasn't clear why he was objecting. And then the judge kept saying, "What are your legal grounds for objecting?" And he was like, well, I don't know that there are legal grounds. It was one of those, oh my gosh, I don't like the answer. I object. Someone's asking about a mistrial. I wouldn't put it past certain people here to attempt to cause a mistrial. But that is my opinion. I'm not saying that's what's happening. But Owens is go on and on. It's a discovery violation. So now the court the court reporter has to look back and repeat the question that Mr. J asked the doctor. So that is what we're waiting for.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Yes. Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition.
So essentially, Kranick is letting Owens know, look, doesn't matter, standing up. I don't understand. I don't know what legal grounds I have for an objection, but I object. That's not the issue. But there is an issue potentially that could be before the court, and that's the issue of this proffer. So we're going to actually deal with the issue, because we're not going to stand around and argue all day and have you read like 87 pages worth of stuff.
The question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply. In her opinion, that was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think Owens is going to be pedantic here. He's going to say, but that's not word for word in this deposition. Maybe he'll say that.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24.
I see what Owens is getting hung up on when the doctor said, I didn't say one way or another. I think that's what he's hung up on here.
I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer...
That's not the issue, Owens. That's not the issue. The proffer is different. With this proffer, it doesn't matter whether she thought she suffered PTSD or not. And that is actually worse for the defense, because whether you believe Dr. Harper or whether you believe that there was no PTSD is not actually going to make a difference at this point, because PTSD, battered spouse, fear, previous trauma, none of that had anything to do with the actions that Sarah Boone took on the night in question, because they were having a good day. Because as Sarah Boone describes the incident, describes the trigger that caused her to grab the bat and strike him, the trigger is anger, not fear. This was revenge, not fear, not a trauma response. It's anger. And Owens, I think, sees this coming. He's not stupid. So he's going to argue about this PTSD part. He's going to try to not let this happen. Because if Mr. J questions this witness well, if Mr. J asks the right questions and it's explained well, then any jurors who are potentially conflating issues, oh, she was abused, therefore it somehow makes this justified. Oh, she was abused, therefore she must have been afraid. They're conflating this when even the facts don't match up. Well, that is going to clear up some of the fog, and I think Mr. Owens does not want that.
They're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, And I, again, like that to be reread back. What the initial question was, what the response was, because it didn't, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent with.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So I can
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
Go ahead, Ms. Smith.
Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
When you're sitting in court, especially near lunchtime or break time, and you have to go through this, it just feels so much longer. I want to fast forward, but I'm afraid I'll miss something. Oh yeah, I could change the speed. Oh, no, I'm not gonna. It's not. We're not actually that far behind. So, I just thought of a meme. Like all these skeletons sitting around waiting for Owens to finish having his upset. I'm not going to fast forward, Jane. I'm just going to wait. We're only a couple minutes behind. It's not bad. I'll just talk to you guys.
you ready, Madam Court Reporter?
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead.
The very last question.
My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Okay. Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
That is exactly what she said at the time of the deposition. This is not different. Owens, knock it off.
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed.
Hello? Okay, what the crap are we all missing, Owens? It's the same as the deposition. And he's saying, number one, it's not the same. I'm trying to figure out in what way is it not the same? Like, am I totally missing it? You guys tell me. So, you guys are just saying, Owens is giving me a fever. Okay. I'm not seeing the difference. And if there is a difference, it's going to be semantic and not substantive. Oh my God.
Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I...
Oh my gosh. So the remedy he's requesting is that the witness, the entire thing, be stricken. Because, good golly, we don't want a professional expert opinion now, do we? We don't want an unbiased opinion by this analytical thinker who is professional and everything, because that might hurt our case. We don't like it. Throw her away. Throw out the baby with the bathwater.
Stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not.
So Owen's big problem is actually Mr. J. Owen's big problem is that he did not anticipate Mr. J's presentation of this, did not anticipate Mr. J's argument that is going to cut through all the muddy water. You want to believe she had BSS? Okay. You want to believe she had PTSD? Okay. You want to believe she didn't? Okay. You want to believe there's violence or there wasn't violence? Sure. Sure. Believe whatever you like. Because there's a bottom line here. None of it matters. And that is based on Sarah Boone's own statement. Sarah Boone's own recounting of the events in question to the expert in front of the prosecution and defense. It's not like that part of it was hidden from the defense, because the BSS, prior incidents, all of it doesn't come into play because it was revenge, because there was no overt act. I think this is great. Owens is freaking out because Mr. J has an excellent point. So he doesn't even have to wade into the weeds and cross-examine on every little detail of everything and drive the jury crazy. Because it doesn't matter. I love it.
Not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me
Excuse me.
I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had, in addition to the opinions that.
Oh, crikey. He just keeps repeating himself. It's like a kid saying, Dad, I want this. Dad, I don't like this. Oh, okay. Son, let's reason. Let's be reasonable. Talk to me. No, I just want to have a temper tantrum and kick my feet and give me time to come up with something because I don't actually have anything. I'm just upset. Okay? let me look through these 87 pages and lint pick until I find something that maybe will work.
That she gave in the transcript.
All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369 Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay.
Oh, wow. Oh, wow. I mean, I guess the judge is right to do this so that, oh my gosh. Okay, we're going to have a Richardson hearing. A Richardson hearing is, they're looking if there was a discovery violation. So now that Owens has alleged it, now they have to look into that.
Thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right. The court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically, my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
The judge will strike it if Owens says he wants that.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right.
So you just, cried and complained about this, but yeah, no, I think I'm just going to handle it a different way.
Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right
Yes.
Oh my gosh. I didn't expect that one. So, one of Owen's complaints is, well, I can't prepare. Therefore, I want the entire witness struck. She can't testify because it's a violation and I can't prepare. So that I can't take a deposition. While the judge is saying, okay, I have a remedy for that. Like, really, if you're going to be on that so hard, we'll do a deposition right now and I myself will oversee it. So this is rare. We're going to get the rare opportunity to see the deposition. So this is outside of the presence of the jury. Very interesting.
With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay.
Owens, okay, crap. Because she's saying my opinion didn't change. So she's been sitting there listening to all this nonsense, knowing, well, my opinion didn't change. Like, what are you talking about? That's hilarious.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Oh my gosh, Owen just set up a trap for her. And I don't know if she was seeing that or not, but she just avoided that. Would have got Mr. J in a lot of trouble. Wow.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
Nobody
You
asked.
asked me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition?
Seriously, this is an unfair question to ask her. This would be different if she had made, say, a diagnosis and that she could reasonably expect that to come up at trial. I mean, she can't sit there and dump every opinion that could possibly go through her head and come up with every potential question that somebody might ask and then spit that out. I think this is an unfair. Anyway, I'll shut up.
Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's correct.
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
So somebody's saying, "Oh, Jay can object to this." There's no objections here. What we are seeing is not testimony at a trial at this moment. What we are seeing is actually a deposition. So the rules in depositions are different. The jury's not in the room. This is a deposition. Okay? So what you're used to seeing at trial does not apply here. Just so if you're just coming in, just so you know that.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure.
There's a remedy for that. They just took a deposition. They just took a deposition right here in front of us. So send the transcript, do a rush on it. Send the transcript of that deposition to Dr. Harper and Dr. Brennan and ask them, does that change your opinion? And they can do that via affidavit, or they can drag them back in for a day or via Zoom for a minute. Does this change your opinion? Because the answer is going to be no. There's nothing substantive here that would change their opinions.
In these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision.
I don't like that I didn't understand. I don't like that Mr. J outsmarted me, so I'm going to cry about it. And now he's pulling a Sarah. Well, if you order me to continue with this deposition, I mean, if I have to, dude, the judge has given you an opportunity to do it here and now. Get what you want. Oh, what? You can't? You can't? So, wow.
It's not in order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom,
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend?
I'm happy to answer any questions. Are you refusing to answer my questions? He wants, what is she supposed to do? Come up with every possible scenario to every possible question and formulate the opinion and hand it to him on a silver platter? Owens, ask a flippin' question. At least narrow it down. Doctor, do you have any other diagnoses that you didn't tell us? Doctor, did you specifically rule out a diagnosis? Right? Owens is butthurt because Jay outsmarted him on the question. He is trying to make this the judge's fault. You're ordering me to, continue with this. He's trying to make this the witness's fault, and it isn't. She's done nothing wrong. It's Owens. Owens got outsmarted and he's ticked.
To express here today as it relates to Sarah Boone, who was on trial for murder in the second degree.
Judge, I'm going to object. The catch-all, vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help.
No, she doesn't. No, she doesn't know what all the questions are going to be. She has her opinion.
Help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial.
Hide and
I
seek, maybe?
disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Warner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Because when you're doing an assessment, especially an assessment of somebody who is either very suggestible or somebody who has motive to lie, you don't ask, you don't go through the DSM list or any list and say, do you have reactivity? Do you have, persistent avoidance? Right? Do you have intrusive thoughts? You never ask like that because depending on what they want you to believe, they're going to say yes or no. So no, she's not going to ask that. This is silliness.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome.
Alcohol use disorder.
Alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
Suffering trauma is different from BSS.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone, suffers from battered spouse syndrome?
She may meet the criteria for that.
So I just want to point out that Owens had the big temper tantrum and wanted the witness struck, was asking vague questions. Here, empty your brain onto the desk so we can look at it, as if he was unprepared, as if he didn't know what to ask. But he's standing there going down a list that he has written. So, and this could be a prepared list, sort of like a standard thing, but he's prepared. He was ready for this. He knew this was coming. He knew he was going to do this. But we just saw this wailing about how unprepared, like it's not fair, because he was ambushed, really ambushed, and he just happens to have the very list he needs to be asking about.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one.
Hold on. I'm sorry, I have to stop. What the heck is going on in the chat? Is everybody being nice to each other? Do I need to intervene in the chat here? Somebody let me know. Guys, is everybody okay in the chat? All is good. Okay. Sorry for the interruption, especially those of you on replay. But if something was happening, I needed. Okay, you're upset with Owens. Okay. Yeah, I don't want to. I want to make sure that everybody feels safe, that everybody's okay. Okay, good. All right, thank you. Sorry for the interruption, especially those of you on replay. I just want to make sure you guys are good.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can...
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record, or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have
asked
not.
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
And we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But
That doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that that the defendant is pursuing.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
All right, the judge had no choice here, but for those who are not for those who are not understanding what just happened, the two detectives on the case are sitting in the courtroom, and the defense wants them out of there, and the prosecution saying, well, they don't need to be kicked out or sequestered because we're not calling them, they're done. And the defense is actually not planning on calling them, but they want them out. Well, just in case we have to argue about something and recall them. Honestly, I kind of suspect that maybe Sarah doesn't want Chelsea there.
Anything else, Mr. Owens, we need to address?
No, sir.
Anything else, State?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
Yes, she did say yes to BSS. The question is, does it make a difference in the actions that were taken that night?
Bless you.
No, the detectives are kicked out now. No, Kepsel doesn't have a right to be there if there's a rule of if there's a sequestering of witnesses and one side or the other is saying that they're not done with her.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
I missed something. What response? Is the jury even going to remember that? And fast forward past the approach. Oh yeah, she's yucking it up with Henderson. No, with Beck.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing, When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we approach the bank?
Yes.
Owens objects. I don't like the answer. This is what I was afraid of. Oh my gosh, Mr. J outsmarted me. Goodness. Leslie's saying she can have every diagnosis in the book. It doesn't change the fact that she zipped him up. And yeah, what she did. Okay, so
Presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't any
hang on. I think I missed something. So I'm just going to let this play out in case I missed something.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge.
Okay, I'm going to fast forward again.
Ready. Y'all can be seated. Thank you. Madam Court Reporter, when you're ready.
Someone in the chat just made a point that I think is worth highlighting. I've been saying it, but I think the person in chat is more articulate than me. Basically, it doesn't matter what diagnosis she has or doesn't have because it didn't come into play with what she did to him with that murder. Jessica, the battered spouse syndrome doesn't matter. The bottom line is it doesn't matter if she was suffering from that or not. What you can believe that or not believe it. It doesn't matter because it does not play in to what she did. It does not play in to what she did. It's not a reason for what she did. It's not a reason for her perception. There's no defense here, basically. But because the defense was alleging that, I mean, we had to go through all this, right? And hear it. Can't have somebody on trial who's saying, but I was defending myself, and then ignore that. So.
Yes, ma'am. Just read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case. Does PTSD or BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat.
Well, that's hilarious. No, it doesn't invade the province of the jury. If it does, then all the experts got to get kicked out. The expert is talking about mental state. That is specifically what all these experts are there for, to talk about perception, to talk about mental state. Having BSS does not equal justification for what she did. It does not equal that she was automatically afraid. So, he is just grasping for straws.
Question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. The prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's It's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play, post-traumatic stress disorder. Battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm.
According to this witness, no, dude, it's according to your client. She's basing this on what your client told her. And the whole time I was listening to this doctor offering this opinion just recently here, I'm laughing to myself thinking, Sarah Boone's own words. It was a good day, enjoying each other's company, fun, laughing. Her own words that she insisted were true are coming back to bite her in the butt. And good. And Owens doesn't like it. And now Owens is characterizing it as, the doctor is saying that. No, dude, Sarah said it.
Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled.
It was asked and answered. Owens doesn't. So the question was kind of long. The question that the doctor was asked in front of the jury, it was kind of long. And you have to be really paying attention to really get it, right? And Owens is having a conniption over there. And I'm sure, that there are gestures and faces being made that the jury's seeing that we're not. And so Owens is having a conniption. It's going to distract the jury. Owens objects before the doctor can even answer, because he knows what the answer is going to be. So now the jury's forgotten this long question. And so then the doctor's allowed to answer and just gives a one-word answer. Well, the jury's not going to remember what it is or put together what it means. So Mr. J wants to have it read back so that it's all there for the jury. But oh no, Mr. Owens knows what he's doing with his interruptions, and he doesn't want that to happen.
There is a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
Jury's entering.
Caitlin, the state is not asking her a gazillion questions because they don't want to get in the weeds. It muddies the water. It gives the defense more ammunition to wiggle around with, to, twist around and confuse. So he's just asking the key points. And there is a mic drop moment here. There is a boom, a zing, whatever you want to call it. And that is, it doesn't matter whether you believe that Sarah Boone was suffering from BSS or not, whether she was suffering from PTSD or not. You can believe that or not believe that. That's okay, because those conditions didn't play into her actions on the night in question. Those conditions did not impact her perception such that she would feel her life was in danger and she needed to respond with force. So those conditions, if they're even present, don't have anything to do with what she did. And that is the big wow. If Owens can stop interrupting and anybody can actually sit down and think about that and get it. Wow.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yes.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copsey.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you revoke.
Yes.
Oh my gosh. Now Owens argued, oh no, she's making a legal opinion. And now he's asking her for a legal opinion. That's hilarious. Just going to try and fast forward past the approach.
Regarding these
Oops.
regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Another question, sorry.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some.
This is hilarious because 22 days ago, Sarah did not yet have the overt act and the hand coming, and the threats and the fear and all of that. 22 days ago, Sarah, that never happened. It didn't exist. So if Owens wants to argue a whole lot in front of the jury about what information this doctor had, he better be careful because it might come out that only 22 days ago, none of this stuff in Sarah's testimony existed. So Owens is going to be having to be really careful where he's stepping.
Some opinions about narcissism, whether or not she had.
Yes.
I'm going to fast forward past the approach. Owens knows what he's doing. He's not stupid. I think there was a big problem though, because Mr. J did something Owens hadn't thought of. But Boone looks happy enough. The reason, J Mac, the reason they approach when they object is because instead of having arguments in front of the jury, which can encourage a little bit of showmanship, they just go quietly up to the judge, have their discussion, and then there's less games happening then. Judge makes his decision and they go back. Because you don't want objections to be affecting the jury. I actually like it this way, even though it's kind of fun to know what they're going on about. So that's why they're approaching all the time. But it's not long. It's not like the Karen Reed trial and the sidebars were just endless.
Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the texts in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct?
And you agree that any...
Permission to voir dire based on.
Let him finish. Let him finish.
Well, I'm going on. I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Just see when Owen said, "Oh, may I approach?" and the witness is oops, the witness is like, "Oh, no, I have it here. Like, please don't approach me."
Refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to voir dire.
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations.
Correct.
And you agree your answer is no.
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk.
read my
First, you
complete
said
answer.
no.
As I said, it made me aware that they had a
Ma'am,
volatile.
ma'am.
It's not my complete answer.
I know, Dr. Warner.
The whole truth. The whole truth. And she knows, she's testified before, she knows this trick. So if a lawyer asks you a yes or no question, or asks you for a piece, like just tell me the part I want to know, if you are, as a witness, are aware that just giving that little piece will cause the court to be misled, you can actually, as a witness, turn to the judge and say, Your Honor, I don't want to mislead the court. Can I please answer? Can I give the complete answer? So, yeah, he's annoying me right now.
But didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
She's so mad.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship, and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
She didn't say that in front of the jury, did she? I thought that was in the deposition. I'm starting to lose track. Oh, somebody in the chat just pointed out, yeah, the jury won't like this guy bullying this woman. Yeah, I don't know. It's going to depend on their personalities, how they handle this. I don't think Owens is looking too good now, but I think I know what he's trying to do. I'm going to fast forward a little bit. See if we can catch up. Not yet. He's definitely fighting hard for his client. No one can say he isn't. Anita's saying, yeah, we've all been questioned like this, not allowed to answer and then getting crap. Yeah. It's very frustrating. Teddy Bear Ears says, yeah, battered witness syndrome.
It is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
I just want to make sure that they're not having more arguments.
State, anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Okay, so it is 12:06 by my watch. So in less than an hour, we're coming back, and I'm going to switch screens and check in more fully with chat. I was worried a little while ago about the well-being of someone in the chat and if they were being treated well. So if anyone has concerns about the well-being of anyone who is here or was here, and that concern is ongoing, feel free to email me. If you are the person who was having trouble, feel free to email me. So Kim R says Mr. J was too nice to their expert. I don't know. I think it's okay. I think that you can cross-examine someone pretty vigorously without being mean, right? Holly's mom says the witness is holding her own. Yeah. And by the way, someone asked if she is indeed coming back after lunch. The answer is yes. Okay, Kim's saying that person left, but you didn't see anyone being mean. Okay. Oh gosh, so someone told her not to talk? That would upset me too. You guys are welcome to speak. You're welcome to vent. You're welcome to have your humor. You're welcome to grieve. Whatever it is, as long as you're kind to each other and you aren't, being overtly, well, actually, as long as you're not, attacking someone based on race, gender, religion, that sort of thing. That stuff is not okay. But gosh, everybody has different opinions, and that's okay. It's not cool to say, you're not allowed your opinion. But you can say, I disagree with you. So, oh, Boole, I see you. When I told the person to speak, the other person dipped. By dipped, do you mean like they left? I hope. So, okay. Good. It's good to take care of each other, so thanks. Oh, okay. So, yeah. So somebody said she doesn't have to watch. I could see that being misinterpreted, especially if someone's already upset. So, okay. All right. I'm going to leave it alone. The person's not here, so I don't want to, talk too much about that. Bycat is saying, do you think they will bring up how he got into the suitcase? If they were going to, then I think they would have already. So I think the strategy is to say, okay, they're not going to be able to argue about what happened or didn't happen in respect to him getting in the suitcase. So they're going to just use Sarah's own words against her. And Sarah's own words are, it was a good day. We were laughing. It was fun. We were joking. Everything was wonderful. What I wondered is if they were going to change the story, change the narrative to, I was upstairs and he came at me. He was screaming at me. He was fighting with me. And he came at me, so I hit him with the bat. And then I didn't know what to do. I could see that as battered, like a self-defense. Sorry. Yeah, criminal minds. Yeah, they're gonna do a Sir rebuttal, and I think what Beck was talking about there was in respect to the issue of the defense wanted Copesel and Owens, the detectives, out of the room. I think it irritates Sarah. Really, I don't think they're really gonna call the detectives back. That was a sort of a reason to get rid of them. So Ada is saying, will they bring up that she said I put him in the suitcase on the 911 call? I don't think so. I think the strategy now is, yeah, we're going to go with her own words because arguing about what really happened, the fact is that she's such a liar, we're never going to get the truth. Okay, guys. Oh, yes. Captain Katie is pointing out one can block another in order to no longer see their comments. And yes, there's no need to be nasty to anyone. Yes, that's a good reminder. You can block somebody if they're really getting on your last nerve. Although, if somebody's in here really intentionally causing grief, I do want to know about it because I want to take action on it. Okay, guys, Watson needs some attention, and we have less than an hour. So I'm going to go do that. And what did he say? He said 1:30. So I have to change the start time on the afternoon live. We'll start at just before 1:30. Thank you all for coming and talking and hanging with me. Trust your gut. I'll see you in a little bit.